We're starting in a few seconds. If you check your phones, please. Welcome, everybody. It is Monday, June 6, 2022. This is a commissioners meeting of Rehoboth Beach. It's a workshop meeting, live City Hall, Commissioners Room, second floor. I'd like to call this meeting to order at 9:01 a.m. Thank you all for being here. Would you please join me in citing the Pledge of Allegiance, please? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You may be seated. With that, I want to start off with roll call. I will note that Commissioner Shanowski is under the weather a little bit, so he won't be here. Glenn, I expect to be here shortly. With that, we'll start with Commissioner Tony Sharp.
Here. Commissioner
Jay Legree.
Here.
Commissioner Shanowski, absent. Commissioner Susan Gay.
Here.
Commissioner Patrick Gossett.
Here.
Commissioner Tim Bennett.
Here.
And Mayor Stan Mills here, so we have a quorum and are able to formally conduct business today. I also like to thank everybody that is watching virtually. Thank you for tuning in. Also like to thank everybody that's here in person. We have a good audience today of citizens. With that, I'd like to remind everybody and that support documents, when they are available, that support agenda items are available embedded into the agenda. Go to the cityofrehoboth.com website. The very center right of the page, you'll find the legislative portal. Click on that and then search for the meeting date and meeting type. And you'll be able to see the agenda and any of the support documents as we see them up here. With that, I would like to make note that because Commissioner Shanowski is under the weather, he was unable to get 2 reports done. That's on no left turns and the topic of 1 Grove Street. And so because of that and because there's no time element that we rush those through, those 2 items will be deferred until the July workshop meeting. With that, we will go to the next item, which is correspondence. We did receive something from Mr. and Mrs. Good in reference to 1 Grove Street. We also received correspondence from Mike Strange in reference to the no left turn, and again, both those topics will be deferred. With that, we'll go to the city manager's report. Kevin, I forgot to, I also like to recognize other city staff that's here. We have Glenn Cumming. We have Lynn Cohen, communications specialist. We've got Howard Rothstein with the building and licensing, Matt Janis with building and licensing, City Secretary Ann Womack, and Assistant to the City Secretary Linda Travers, as well as interim and Assistant City Manager Evan Miller. Thank you all. Sorry I missed you. And with that, we'll turn it over to the city manager's report. Evan?
Thank you, Mayor. Good morning, Mayor, commissioners, members of the public. 2 University of Delaware environmental engineering students have joined our staff for the summer. Grace Wooten, a rising sophomore from Newark, and Lance Wonder, a rising junior from Pike Creek, will work under the direction of Public Works Director Kevin Williams into August. They'll be assisting with several ongoing projects and also bounce around among several departments to learn about the inner workings of local government. So I just want to welcome Grace and Lance, who are with us today.
Wave. There you go. Thank you. Welcome aboard.
The 1,000 square foot addition to the Delaware Avenue Comfort Station will open on Wednesday of this week. The addition includes 2 family restrooms and 7 changing rooms. You'll recall that 2 of the changing rooms are accessible to persons with disabilities. Our beach continues to recover from the Mother's Day nor'easter. Over the past 7 to 10 days, we've noted significant improvement to the beach depth, thanks to an assistance from Mother Nature, of course. 2 of our 38 beach dune crossings remain closed due to the storm damage and are going to require Denrex equipment in order to repair those crossings. Those 2 crossings are the ones on Surf Avenue and one of the 2 located at Maryland Avenue. Denrec began pushing sand to the closed crossovers last week and plans to begin trucking in sand for the Surf Avenue crossing is this week. And if surf and beach conditions are favorable, of course, Denrec will perform that work, and our city staff will continue to replace the damaged sections of dune fencing. Just one note on our electric vehicle charging stations here at the City Hall Convention Center parking lot. There is one that is down right now due to a malfunctioning head on the charging station that needs to be replaced. So due to supply constraints, it may be several weeks before it's replaced, but we're working on getting that repair performed. And that's all I have, Mayor. I'll answer any questions you have.
Thank you. Any commissioners have questions? Commissioner Bennett?
Yes, I had a neighbor ask me a question about a letter he received last week about lead piping. Could you clarify what that is? I was a little confused.
Sure, and I believe during the last city manager's report, I had mentioned that. So this past week, a letter went out about the lead service line investigation that we are doing. This is a project that we'll undertake over the summer, mainly in regards to, again, just trying to get a better understanding of what infrastructure we have out there. And it's mandated under the EPA's new lead service line program. So it's something that we'll be undertaking this summer. So
do they need to be here? Because the one question was whether they needed access to the house.
I don't believe, in some cases they may, but we do have in the letter, there's contact information for Robert Downs, who's the water superintendent. So if there are any questions related to that, feel free to contact Robert.
Okay.
Yes.
Thank you.
So it may be an individual basis as to whether or not we need to access the house. So
thank you.
Kevin, on that topic,
sure.
I only got one question, which was relevant to the timing of it.
Okay.
Which folks with this particular individual thought was a bit odd that we were doing that during the season as opposed to an off-season project. Could you?
Sure. Certainly during the summer season, we feel as though more property owners may be available in the event that we do need to access the home. But again, if there's any concerns about the timing or the property owner wanting to be there, although they might not need to be there, again, if they could just contact Robert Downs.
But it wasn't about timing. It was about resources. They were wondering, why are we deploying resources to do this during the summer high season as opposed to off season? And I didn't know if these are city staff doing it.
It is city staff.
Yeah,
yes.
so their concern was of all the things that are priority for visitors as well as residents and property owners, et cetera. They thought it was just a curiosity of why it was high season.
Yeah, so typically a lot of the projects that we undertake do take place in the off season, and that's because of the seasonality. So during the summer, it's not often that we're doing water line replacements, water meter replacements, things like that. So typically there is staff time available in the season, oddly enough, to do projects like this.
Thank you.
I have actually several questions, Evan. First of all, I was disturbed to see that we've had more graffiti damage at the new Lake Gerard playground. I think it's like 3 times now.
Okay.
And are those just being cleaned off each time, or what? Is there any progress made on finding the culprits or anything?
Yeah, so we're certainly investigating, and we are cleaning up the graffiti as much as we can. We've been in contact with the playground manufacturer who has come out, and they've given us an estimate to repair the equipment that's been damaged. We've also been in contact with the insurance company about filing a claim. So at this point, it's just a continuing investigation to try and find out who's doing this. But we are on top of it in terms of trying to clean it up and getting in touch with insurance.
And it is open and in use.
It is, yes,
meantime.
absolutely,
Okay.
absolutely.
Right. That's good.
Yep.
Okay, and then one other question I had.
While we're on that, I would just like to say where I think need to be more proactive is in prevention.
Yeah.
because we keep trying to replace it. What we found out is graffiti cleaner, which has toluene and all these nasty chemicals in it that normally removes the graffiti off of stop signs and stuff, is not working on the specialty material of the playgrounds. It's not working. It can't come off. Where it does come off, it leaves haze or ghost. So again, we need to be a little more proactive somehow, and so that we were looking at.
Well, I'm glad it's insured.
Thank you.
Then the next question I have is actually July 1st is quickly approaching, and the change in the trash with having to have the tippable containers. And I just wonder, I know that the card went out a few months ago, and I guess I'm wondering if there's going to be another, notice, maybe a newsletter or something about it, if there's going to be any grace period, because as I said, July 1st is right around the corner, and I'm not sure whether everybody remembers that it's happening.
Right.
So.
Yeah, we'll work on continuing education on that to make sure everybody's aware.
I mean, the good news is, as I was coming this morning down Country Club Drive and down Munson, the great majority of cans that were out were, so I felt really good about that, but I know that I still haven't gotten mine from the city, and I need to do that. So it just made me aware that perhaps others are going to be caught short as well. And then I guess the last thing is, this is a subject that came up kind of tangentially in our CDP discussion last week, but I wanted, because people have asked me the question, I wanted to air it at this meeting, and that is about the dock. My understanding is that the contract is being finalized for the water taxi service, and I think they start their tours in mid-June or something. I think I saw on their calendar. But last year, we approved contracts for, in addition to the water taxi, the kayak rental. And you had mentioned that the kayak rental was not going to happen this season, right? And I'm not sure people are aware of that. People have asked me. And I've said I've heard that it's not going to happen this year. But we issued an RFP, and we got some proposals in, and we selected one. If the vendor we selected is not going to do it, would we be putting out a new RFP, or what will we do there?
Yeah, so we've had some discussions about that, certainly. I think one of the RFPs that we received was actually from a possible vendor that didn't have any of the equipment just yet, that they still had to purchase kayaks, things like that. I think we certainly could put another RFP out. My feeling is to just wait this summer and go back to that vendor, at the end of the summer and start working out some of the details, the logistics for next summer. Because I think some of the concerns that have been shared by the kayak vendor that we had selected would be concerns that would be shared by any vendor, mainly in regards to emergency access to the canal. Where else can they access the canal in the event of emergency that's not necessarily City of Rehoboth Beach limits? Certainly carrying the kayaks down the switchbacks to the canal was a concern. The storage of kayaks in the event that they would request to store the kayaks, parking for any vans, things like that. Just some of the, again, logistics, emergency concerns that are out there, I think, that are ones that need to be resolved regardless of who operates there.
Well, and along those lines, do you have any sense of usage? I mean, do we have are people using it on their own?
I believe so. I think Lynn's received probably numerous phone calls from those asking about how to use the dock, asking about the storage of kayaks down there. And I know that some people have reached out asking about the vendors that are operating out of there. So we've been advising them too that taxi service is coming, but the kayak rental is sort of pending at this point.
But people are using it on their own, with their own
absolutely.
personal kayaks.
Yes, yep.
All right, thanks.
So on that topic, I'm just curious, as we look down the road like 5 years from now, and we are trying to assess what's the ROI on this project just in general from the 30,000-foot view, are we keeping any or monitoring any statistics so that we'll have a base to know where did we start from with recreational activities and where have we been able to progress?
Sure. I think a lot of that information will come from certainly the taxi company. Once they start operating, they'll have an idea of how many people they're running tours for, or taxi services for. I will say that we're contacted almost daily because the gate down there right now is a little bit difficult to open. Some people think that it's locked, but in most cases it is not locked. So I know it's getting used heavily, but in terms of statistics, I don't know that we have any just yet, only because nobody's down there to really man it, if you will, daily to observe the traffic down there. But I do know that just from the calls that we receive, questions, inquiries, things like that, it's being used pretty heavily.
Well, and I only raise it because at some point in time, anecdotal activity of we know this and we know that, you may not be here, I may not be here.
Sure.
Others may have a different view
Right.
of we need to know
Right.
For a proactive approach.
Sure.
So
Yep.
just food for thought.
Yep.
Thank you.
Well, and also on that topic, I'll let you know that former Commissioner Pat Caluzzi, board member of the LRCIA, Lewis Rehoboth Canal Improvement Association, has approached me and asked to be on the agenda for the July workshop. They would like to make a presentation on seeking an RFP to put a kayak launch on the north side of the canal bank there, or canal dock area there. So they're thinking about it also. And so that may help relieve some of the concerns and problems expressed by the vendors for kayak services. Anything else, City Manager, Commissioner Legree?
Are we keeping track of anything for safety's sake? Do we patrol the area? Are we keeping the lights on?
Yeah, so we actually recently had we had gone down there, and a number of city staff went down to review or just take a look at the dock for warranty purposes. There's a 2-year warranty on the dock, so we went down, did an investigation. All the lighting's working as it should. We do have the streets department that goes down in the morning to unlock it, the police department that goes down at night to lock it. In the morning unlock, at night lock it. So there are, at least 2 times a day, there's city staff down there taking a look at it, doing maintenance, whatever it might be. So,
what time is it locked and unlocked?
in the morning, I believe it's maybe around 7:30, 8 o'clock, and then at night it's usually around sunset.
Okay.
Mm-hmm.
Question number 2.
Sure.
When we were trying to find a place to put the last historical marker, it happened on the Prospect side of the boardwalk. We were told that there was no moving anything east of the boardwalk. I see we have a permanent sign on tents, canopies, and explaining that ordinance several feet down down the entryways. Is Denrick doing that, or how did that happen?
I'd have to take a look at the situation or the location that you're talking about. Is it a sign on a existing dune fencing post?
It's a sign on the right at the fence,
right.
and it's an access way, and
Okay.
it's a great message.
Right.
Don't get me wrong.
Right.
I just didn't realize they let us get out there.
Yeah. So certainly because that's an existing dune crossing fence post, we had just affixed one of our regulatory signage there. But something like a historical marker is much more significant, needs a foundation. It's extremely heavy, large. So there's certain requirements, and I think that's why we were looking at the east side of the boardwalk down there by Poodle Beach.
How many of these signs are we going to, tent ordinances are we going to put on?
I'm not sure. I'm not sure how many we have out there now, or if there are any plans to put any others out there.
The same question goes for recycling cans.
Sure.
Are we going to continue to put recycling cans out?
Yeah, so we have put some recycling cans out now, mostly in the area of Rehoboth Avenue, a little bit further north, a little bit further south. This is really just a trial period to see how it works. We have seen that there's been some contamination, so this is really just, again, our trial period to get an understanding as to how often it's utilized, if there is contamination, and then from there, we'll make any adjustments needed to expand that program.
Okay. I think I counted 6 or 7 yesterday, and it's, as we know, it's great, and
right.
it's a staffing problem.
Sure.
But it's it's nice to know that happened.
Yeah.
Especially being chairman of the boardwalk
Right.
committee.
Right.
It's nice to know that there's a sign out there, and nice to know that the recycling cans have been placed. And,
Right.
And that's great.
Yep.
Thanks, Evan.
Absolutely. Thank you.
Well, if you get wind of a guy opening the can lids and taking pictures of the contents inside, that would be me.
I have a couple other questions, if I
There
may,
are
Mayor.
some contamination issues, unfortunately, but.
You can share pictures, because I've been doing the same thing.
Like follow up.
Commissioner Gossett.
Yeah, Mr. Miller, on follow up on the dock, you had mentioned about going down with city staff and reviewing maintenance operations.
Yep.
As part of the negotiated agreement, if I remember, that LRCIA was to take care of maintenance for the first 2 years.
Right.
Were they a part of this inspection?
They were not, no.
Has there been any outreach to them as to their responsibilities?
There has not. No, not to my understanding. This was really not necessarily the landscaping maintenance or anything like this, but this was strictly just construction warranty.
But as I remember the agreement, that was not limited to landscape. It was complete maintenance of the dock, the maintenance of lighting, what have you. So I would appreciate it that if they are not been contacted, they'd be part of this process.
Absolutely.
As part of the agreement.
Yep.
And also, if you negotiated a contract with the water taxi, what is the financial responsibility or what is the charge to them for the annual contract?
Contract, I believe it was $1,000.
$1,000 for the year. That's what we're charging them.
Yes.
Okay. And then could you also give us a little update on staffing with regards to parking, beach patrol, streets, and police cadets, as where we stand?
Sure. So in terms of, I guess I'll start with streets. Streets, we pretty much have a full complement. We now have, usually during the day and during the night, especially on weekends, we have about 7 seasonal employees working. So streets department, we're doing well. Beach patrol, we're also doing very well. Parking is still, we're having some issues in terms of hiring seasonal enforcement officers, also office employees. So we have continued to advertise in local newspapers. We've also gone to the extent of contacting the temp agency that we work for. So we've been fortunate enough to receive some help through the temp agency. So we have hired a few folks over the last couple weeks, which has been helpful, but we're still at the point right now where we are needing to close the office at 6 p.m., but we still have somebody available to answer phones or dispatch a tech after 6 p.m. So we're still continuing to work on that. And in terms of police, we're doing very well there. So.
And the installation of the new meters, which I know you've overseen, and they look great. Are we able to get either a weekly or some type of cyclical report on revenue generated and that type of thing?
Yeah.
If you could supply that to us, that would be great. Thank you.
Yeah.
Anything else from Evan?
I just have one last, which is I did note the disappointment that was publicized from Ocean City about how their Memorial Day weekend did not meet their expectations from a business standpoint or a visitor standpoint. And I was wondering if we have any intelligence on how it really stacked up for the city of Rehoboth Beach. And I note Ms. Everhart is here as well, so I'm kind of wondering, because I've been asking that, do we believe that because of gas pressures and the things that did surface Memorial Day weekend in Ocean City, that we may feel some of that as the summer goes on?
Sure, yeah, and certainly I'd defer to Carol to speak on behalf of the businesses, but from what I heard, I mean, everything was, you know, a typical Memorial Day weekend in terms of visitorship and just, you know, how busy we were downtown. I think also it was the weekend before, the 2 weekends before, the really nice weather. We got hit pretty hard too with visitors because it was just such a beautiful weekend. So I think that helped prepare us for Memorial Day weekend as well. So,
Carol, do you want to offer anything? Oh, wait. We're going to turn that mic.
Well, I think Ocean City was mentioning as well that they would be monitoring some of the statistics a little bit later on in June. So I know you're on top of it. I'll keep asking about it. And, you know, I'm sorry for Ocean City, but if it doesn't impact us, that would be great. Okay.
I spent some time yesterday talking with the owners of Ryan's, and if their business is off, everybody will be off. If they're doing great, everybody will be great, in my opinion. And they had a great Memorial Day, but this last weekend, Sunday, Saturday was not. She said it was.
Well, I think
off.
that's typical.
That's pretty
Yeah, that's typical because the schools are still in session.
Sure, and that's what she felt like, or that's what they felt like the problem was. Thanks, Mayor.
Walter, you have something relative to what we're talking about, or should it wait to citizen comment at the end?
No, it's Walter Bringham, 123 Rehoboth Avenue. Last year, I brought up the questions about the problems at Mariners Park near the Hamilton condo. Yesterday, I found the person backed in, and I talked to the gentleman from Maryland who happened to have a license plate on the front of his vehicle, and I explained to him that our old people that ride around in their fancy vehicles give him a ticket because he was backed in. And in the process, I went over and looked up on the sign, and we have, I think, new signs up on the oceanfront. Was that the correct, Kevin?
Yes.
And those new signs have wording that high. That's the tallest item, or excuse me, the shortest item, and it says that pull-in parking is required.
Mm-hmm.
And I don't think we should be treating people like that. You go in, the signs are mounted at 9 foot. They're 18 by 24. I don't know who did them, sign wrong or somebody. But when you're there, you look down. In the Army, you look up to find the snipers in the trees. You're not expecting a line like this that says, you might get a ticket. And they are avid. I don't know. I know you can probably trace it. But we should have new signs put up, or we should have bigger signs put up. If we're going to ticket for that, it's just not right on how we're treating our visitors. I do not know where else in town those signs, type of signs exist, but it's confusing. So generically speaking, I think in most cases you're supposed to pull into, to a parking space. But I see people out here in the lot out here pull through so that they can pull out, and that puts their license plate to the back on the inside where it can't be read. And I think we need some uniformity to this. I think we need some honesty and integrity in how we would like to be treated when we went someplace else. And I think it needs to be settled. I brought it up early last year. Nothing happened. Kevin was in a different capacity, but I did not know at the time he had been made head of the parking section. I don't expect Kevin to know anything about it, but I don't think the people know about it either, and I think that's wrong.
Walter, do you have anything else that should be a citizen comment at the end? Because we're holding up our meeting.
So I've asked about Hamilton Avenue and Columbia Avenue. What's the process for stoning, adding stone to the side of the right of ways?
This is not a discussion, Walter. Make your point. Make your point.
Okay, we have too many people putting stone on the side of the streets that's messing up the drainage. We talked about it beforehand, and I think most of you don't have a clue what I'm talking about, but it needs to be addressed. But after a while, we don't have the problem where you have curbing. Jumping away, I see down at the triangle at the lift station, we have a new irrigation system being put in, probably under the grant. That's people generally don't know about. What is that whole project costing? Something left.
I don't have the quote in front of me, but you're correct, Walter. It is a grant or a CTF grant that we received maybe about a year ago for the landscaping of the State Road Triangle there. Yep.
I also remember we asked to see a copy of the master plan, and I don't think sign is, separate.
Walter, one more thing, and then you can have all the time you want at the citizens' comment at the end, but you're holding up the meeting.
City manager, sir, we have no place on the agenda to have it. Do we have a lease on the museum property?
Yes.
Thank you.
Mayor, if I could just,
Excuse me, one last thing.
sure.
Commercial licenses in the city. You have all kinds of stuff about general parking. What are some black and white rules for commercial parking in the city? Do they exist, black and white? The enforcement is ridiculous. 50% of the people, the lawn services, the plumbers, everybody, they don't have parking permits. Unequal enforcement.
Walter, you need to give a clearer picture of what you're talking about.
Okay, first of all, you ride down the streets, half the lawn service people park out into the street. I don't know whether they have licenses, I don't care. But they need to be parking off on the shoulders. But ride down the street, and I look at them, I'm not doing a survey, but I do a cursory survey, and most of the plumbers and people like that, the parking enforcement officers don't have a consistent policy. Well, if it appears that they're working there, we don't require them to have it. I don't believe our black and white laws reflect that. I think it was a huge amount of money, and I think I could challenge those things, and I think you're wrong for not bringing it up, and we talked about it beforehand.
Thank you, Walter. Any further comment of the city manager is what we're still in. Commissioner LeGree?
Evan, do we have any way to have the folks who attend this meeting be able to park in our parking lot without having to pay the meter?
So we do have the designated spaces directly behind the fire company. Also, too, typically what we do is in the event that somebody does park and they're attending the meeting and they were to get a citation, if they bring it to the parking department, we'll usually get rid of that citation.
Okay. And one more, I'm sorry.
Sure.
Parking in front of the post office, how do we enforce that? I had a citizen ask me, I think she was ticketed for parking in front of the post office.
Right, and I don't recall the post office hours off the top of my head. I think they're open until 5 or so. So it's reserved parking for the post office. Do not need to pay the meter before 5. After 5, it then turns into metered spaces.
The ones
In front of
Rehoboth
yes.
Avenue.
Yep.
After 5 meters. That makes sense.
Yeah, the signage I think has the hours on it, but I believe it's 5 o'clock. Mayor, if I could just clarify one thing in terms of the parking signage that Walter had mentioned. So we do have parking signage, which we worked with Park Mobile. Park Mobile supplied them for the city at no cost to us. At the top, it does have our regulatory information, which mentions head-in parking is required. All of the parking meters also have an introductory screen, which says that head-in parking is required. The exit screen also says that head-in parking is required, and the receipts also have the requirement that head-in parking is required. If an individual was to not use the meter, not see the signage, and pay via Park Mobile, every Park Mobile session starts off with an alert that says that head-in parking is required. That alert shows up before they can even start a session with Park Mobile.
Thank you. Anything else for the city manager? Yeah. Yes, ma'am. With that, we're exiting city manager's report and going to city solicitor's report. Well, that's easy because he's not here. Old business, none has been identified, so we're going to move on to the first item of new business. First item of new business is discuss a draft ordinance to amend Municipal Code Section 270-19 use restrictions of the zoning code to permit a restaurant dining patio to exist on a parcel abutting the parcel upon which a restaurant is situated, whether or not the parcels are in common ownership. None of these topics tonight have anything to do with dining on public space, meaning nothing, no discussion is to take place specific to dining areas on public sidewalks, because that's public space. We are restricting our conversations to private lots and private ownership. I was going to turn to Glenn to explain, and so I guess I'll do my best to explain the situation. We have a situation where we have an existing prohibition on the ability for a restaurant selling alcohol to establish and or expand private patio dining on an abutting property of different ownership than the primary premise the restaurant occupies. In other words, if the restaurant selling alcohol is licensed and permitted to have an outdoor dining area on their premises, and they want to use the lot next door, if they also own that lot, it's in the same ownership as the main lot that the premises is on, restaurant premises is on, then that's within the code. If, however, the licensed restaurant wants to establish or expand onto a neighboring property, a dining patio, and that neighboring property is of different ownership, even if it's the same two people owning it, if the name is in different ownership, they're not allowed to do that by our zoning code. Our zoning code disallows that use. Specific wording has to do with accessory use is how they would look at it on the abutting property. So we have talked about this, I think, multiple times in front of the mayor and commissioners at public meetings. And there are different options on how to address this. One is to do nothing, in which case the applicant, the restaurateur, can choose to go in front of the Board of Adjustment to seek a variance, because this, again, is a zoning code matter. And our Board of Adjustment is officially called the Zoning Board of Adjustment because that's primarily what they take care of, zoning issues. And then we put it in their hands, or the restaurateur and the city put it in the Board of Adjustment hands to determine whether they would allow the private dining patio to expand or be set up on neighboring property of different ownership. So there is one option that we do nothing. The other option we talked about is to revise the zoning code to make it allowable per the zoning code. And if you recall one of our last meetings, we talked about extending the suspension of rules till November 1st, primarily in order to have sufficient time to address this topic. And so those options were presented at that time. So we have in front of us and embedded in the agenda as a support document a zoning amendment. This is a proposed draft amendment of 270-19, which is use restrictions within the zoning code. And the proposed draft language says, dining patios, this is again new to be added as an item 9 at the end of 270-19. Dining patios may exist as an accessory structure on a parcel abutting the parcel upon which the restaurant is situated, whether or not the parcels are in common ownership. In the event the parcels are not in common ownership, no supplemental permit of compliance shall be issued unless the owner or owners of the parcel upon which the dining patio is to be situated certifies in writing that the applicant for a supplemental permit of compliance has been granted permission to locate the dining patio on the owner or owners' parcel. There's two parts to this. One is making an amendment to the zoning code allowing the establishment of a dining patio or the enlargement or expansion of a dining patio onto the neighboring property if it's of different ownership. One, if that is adopted the zoning code change, then there's still a second step. And that follows our current program of seeking a permit of compliance. It's a supplemental dining patio permit of compliance. So there's 2 steps there. Again, this is a zoning code issue. And because it's a zoning code issue, we have to follow certain protocol to be able to change the zoning code. And one is to have this discussion. One is to get to the point where we want to pursue it further. One is to adopt a resolution setting a public hearing on this to hear public feedback about amendment to the zoning code. And then conduct the public hearing and then conduct a vote on it. So there's multiple steps in there. There's time for public input. And again, if this passes after a public hearing where we receive public input, then there's actually another opportunity for the public to give input, and that is during the actual permit of compliance hearing. So there's 2 shots there. So with that, darn it, I'm mad at Glenn. He usually reads these and saved my voice. So anyhow, I want to open that up. This is something that want to get resolved sooner than later because of the expiration of the suspension of rules. November 1st is going to come up quicker than we think. So I'd like to open it to the commissioners first, and after the commissioners have exhausted discussion, then we'll open it up to the members of the public here. Anybody?
Well, Mayor, first of all, thank you very much for bringing this up now. I agree with you. It probably will take some time to finalize, and the sooner we get to it, the better. So I'm very appreciative of that. I have actually a number of questions. I'm going to start with a very basic one, and then come back to the others later. I just want to clarify that this is only for restaurants serving alcohol, this provision going into the code. So if there is a restaurant that does not serve alcohol and wants to expand onto a neighboring property, they would not be able to?
As far as I know, yes, because of the way the proposal is written.
Right, okay. I just want to clarify that because I've been asked that, and that's what I thought based on where it is in the code, but just wanted to clarify.
Yeah, I hate to burden you, but you are the commissioner's secretary. Would you take some notes? Would you make that note? Because we want to run it by our city solicitor when and if he gets here. All righty, so there are going to be some things that we are going to need to do further research on. Again, so...
well, there'll be more. I assure you there'll be more. Okay. So I'll make some notes. Thanks.
So give you a second to record that.
Yep, okay.
And then go ahead and resume.
No, actually, I'm going to leave it. I'll come back to other things.
Well, if we're waiting on anybody to speak up, you know, I've been in favor of considering amending the zone for quite a while. My intention all along in allowing restaurants to expand their private dining patios on the neighboring property was I assumed it was moot. And then we find out that when some applications were made, that the restaurant tour and the building and licensing found out that the abutting property was in different ownership, and that kind of led to this whole thing. So I am very amenable to giving consideration, going to a public hearing to hear more public feedback on this. However, I don't know all the ramifications of this. And that's why I'd like to hear more from the public and willing to go to public hearing on this issue. Anybody else?
Yeah,
Gossett, go ahead.
Address this to the Building and Licensing Department. The phrase that's used here is accessory structure. And could you help me understand better how that applies across the board, if you will, as opposed to if we apply it just to this particular instance with restaurant expansion of dining patios? how is that, or does it impact any other interpretations of accessory structures in the code or applying it?
I think it's important to remember, and thank you, Commissioner. I think it's important to remember that an accessory structure cannot exist without a main structure. Essentially, what you would be doing is making an exception to that zoning ordinance in those relative cases. I think you could stipulate it that they could only exist in these relative cases, and anything above and beyond would not qualify.
And I guess turn to Glenn for take a note here, I guess. But could that also then be interpreted as spot zoning, which is illegal?
I would certainly have to confer with Glenn on that. You may have a point.
I just, carving out specific requests, again, I support the expansion, what have you, but it just a question of how we can legally approach that with regards to, since it is part of the zoning code.
It's few and far between that it would occur, but certainly in some cases it certainly could occur that an accessory structure associated with a restaurant could be in a different zoning. We'd have to take a look at each individual application and see, what exists where. But
I'm not specifically addressing that it's in a separate zoning code, but just that we're only applying this exception to a specific occurrence. Right. And that, so I would want to put a swimming pool on my adjoining lot in my residential. That would not be allowed, as I understand it.
Correct.
But if I want to put a deck on my adjoining restaurant, we're allowing that. So I don't think that an equitable application of the law, and I don't want to get us in question about that. It's kind of like one size fits all or doesn't. So I'm just concerned about how that would be interpreted in the future, and swimming pools, tennis courts, what have you. There could be a number of garages, sheds, goes down the line. So I just want to be equitable in that sense. How that is applied. And Glenn,
Matt, can I get you off the hook?
Absolutely.
Maybe we have to defer to legal.
Thank you, Mayor.
Along with that, and since you're up there, I'll ask you about this.
Sure.
No, that's fine right
because
now.
this is going to be a question for Glenn too. But I think we're going to need to add a definition in the code, because there is no definition for accessory structure. There's a definition for accessory building, and there's a definition for accessory use, and there's a definition for structure. But there's no definition for accessory structure. And in the accessory use, which is what the mayor mentioned when we started, that's really what this is, very specifically says it's a use on the same lot. So to the extent that we're adding something, we also need to define, I think, what we're talking about, because it's not defined.
I believe you're correct, Commissioner. Yes, thank you.
And a question also in additional language here, it talks about situated certifies in writing. And I'm curious to know as to what that document would be. Do we have any parallel situations where we require that type of, if you will, documentation or agreement between the owners that the city accepts? Or again, I think it's just curious as to how is this created, if we have any thoughts.
I believe there's some different licenses that exist within the city right now, leases and things, agreements that allow certain pieces of property to be used for certain purposes. It may be something that we want to look into in the development of this. Something, all things to consider as we walk down this path.
I believe those existing, though, as far as I'm familiar with them, are city-owned property or permission to go into right-of-way for city-owned properties or residentials in sidewalk intrusions or steps or decks or something of that nature. So I don't know if that's kind of apples to apples, but I think it's something that we need to further investigate about a certified in writing, just what that document is.
I agree.
Okay.
Anybody else? Yeah, Commissioner
Mayor,
Sharp?
reflecting back on, as you started this discussion, you said we had two choices, and one was to do nothing. And I just wanted to say I'm not in favor of doing nothing and turning this over to the businesses to work it out with the Board of Adjustment. So I'm very much in favor of the other option, which is to continue on the path of getting the public input for a potential zoning code change here and coming to our meetings with all legal opinions ready for us to discuss and just keep this process moving.
Well, one of the outcomes of this meeting is that we get some public feedback, and then we'll get some additional feedback. Likely, this would continue over the July workshop meeting, and we'll go from there. But I was hopeful to hear one way or another which way the commissioners wanted to go, because if the majority wanted to just let it go to the Board of Adjustment, then our work is easier. And if not, then we pursue that process to further discuss, resolve any of the legal questions or any other questions, as well as to then seek setting a resolution, setting a public hearing, and conduct a public hearing, of course.
I prefer the hard work approach, which is this. Yeah.
Anybody else before we go to the members of the public? Commissioner Bennett, please.
Yes, I still am hung up on the 750 square foot.
We're not there.
Am I on the wrong page?
That's the next topic.
That's why I'm confused then.
Yes. But now you're not confused.
No, I'm not confused.
Go ahead.
I know.
State your question, and we'll see whether it's appropriate now or later.
I'm sorry.
No,
as I was looking at the ordinance in general, it has the 750 square foot limitation in again, and in discussing the whole thing in general, I was just wondering if that was also up for discussion.
That is agenda topic B.
Okay.
So agenda topic A is specific to the topic we're talking about now.
Thank you.
Which means specific to facilitating that a restaurant that wants to use an abutting property of different ownership is allowed to by the zoning code to do so. That's our only topic right now. Our next topic has to do with 750 square foot size.
Thank you.
limitation.
I'm sorry.
Hey, you're good. You're just ahead of yourself a little bit. If there's no further comment by the commissioners, then we're open to the public. We're going to ask you to state your name, your relationship to the city, but you're going to have to use the podium up there. Anybody for this topic? Harvey Shulman.
I'm Harvey Shulman, 149 Henlopen Avenue. I'll start out by saying that generally I'm in favor of this notion of expansion of dining facilities, but I don't think this draft ordinance is even close to ready for prime time or public hearing. To me, it seems to be a total mess and a lawyer's dream and a potential city nightmare. As Commissioner Gay pointed out, there isn't even a definition of accessory structure in the code. The word is used a few times in the code in other contexts, and it's hard to really argue that there would be a big dispute over those other contexts because they tend to be on the same property. But now you're creating something that you're calling an accessory structure that's on somebody else's property. So I think you have to look at defining accessory structure. The other thing I'd want to point out is that I'm not sure the way this draft is drafted, it would actually get you what you want, because it would still be an accessory use, as one of you said, and actually as Matt said. An accessory structure or accessory use has to be accessory to something on the same lot. So you're allowing an accessory structure here, which is a dining patio, to be on another lot, which may be a dry goods store or something. But certainly a dining patio on a commercial lot, which is not a restaurant lot, it's some other type of retail business, it's not an accessory use to the other use of that lot. So I'm not sure that just saying an accessory structure can be on the lot next door does it. I think you may have to say that an accessory structure and an accessory structure to the restaurant on the next door lot and an accessory use to the restaurant on the next door lot can be on the second lot. As far as common ownership, I don't know the extent of the problem you're looking at. I understand in some cases there are, for example, 2 different LLCs or corporations, but the ultimate owner is the same. It's the same one individual or 2 individuals, and they have separate ownership for legal reasons, LLC A and LLC B, but Tony and Stan are the owners of the only 2 partners in A and B. So if that's what you're trying to get at, there's a more narrow way to do this, and it's done all the time, you know, that the lots have to be ultimately in common ownership or common majority ownership. So you don't have 2 completely unrelated ownership situations. You actually have people, at least as a majority, who can make a decision regarding Lot A and Lot B. Now, why is this important? It's because I'm concerned that once you grant this accessory permit, that there'll be some expectation in the different lot owners that they will automatically get renewed. If that's the case, it may be viewed by them as a property right. And if you then don't renew it, if there's an expectation it's going to get renewed, and you don't renew it, the city may be in a position where it's accused of taking somebody's property without due process. And I really can envision a lot of lawsuits about that. You know, I own a restaurant on property A, and the owner of property B, who's not me and the same people, is willing to allow this arrangement to run forever. And of course, the value of my restaurant, let's just say, is $1.5 million because I have a permit to have dining not only on my lot, but on the lot next door. But then the next year, for whatever legitimate reason, the city doesn't renew that permit next door or reduces the number of dining spaces or whatever. Well, the value of my restaurant is no longer $1.5 million. Maybe it's $1.2 million. And so can the city take something away from me that it granted last year and 2 years ago and 3 years ago? Can it do that without compensating me? It's a little bit like saying, you know, you have your house and it can be a certain size, but now you have to cut off your back porch. So this is a big issue in a lot of other cities that allow these kind of situations where something is permitted, and particularly when it's not on the same land as the original business or property for which it's permitted. So I think if you move ahead on this, there needs to be something in this that says that this is not a right, you know, that this is, there's no expectation of renewal, you know, that this is something that the city can decide after, you know, a legitimate process that it's just going to not renew anymore. It may be, for example, that there become too many of these, you know, and people complain. So I think that needs to be added to this notion here. I would also say I'm not sure if much thought has been given to the implications. I think the mayor said, you know, what consequences can result. We know there's no setbacks on commercial property unless it's next to a residential zone. But you know, this is a situation where, one, do you want this accessory use / structure dining patio to be allowed to be anywhere on the lot next door? Can it be in front of the building? Can it be behind the building? There may be legitimate reasons to limit the location because, you know, who knows what else is behind the building. So there's no statement about location, which of course leads one to believe it could be any place on the lot. But maybe more significantly, and this goes a little bit to what Commissioner Bennett was saying, although it goes to other things as well. There are restrictions in the code in Article 3 in the code on height, density, and area requirements. Now, some, as I said, like setbacks don't apply here. But even in commercial areas, there are limitations on FAR. There are some height limitations depending on the tier. There's even minimum lot dimensions, which is interesting, you know, 5,000 square foot, although there's grandfathering. But you seem to be allowing this expansion to occur on the lot next door without any, at least evaluation of what this might mean for calculating FAR, for what height might apply. Obviously, no one's going to build a, I don't want to say obviously, but it wouldn't seem anyone would build a patio at 30 feet high. But I don't know, can a patio be built at 15 feet above ground? You know, does it have to be limited only to a certain level above ground? You know, especially if it's in the front of the building or the side of the building. I mean, there are a number of restrictions in Article 3 on height and density and lot size that could come into play here. So if a lot is undersized, do you really want the lot next door that's undersized to be able to have a huge chunk of it be this 750 square feet or whatever it is? And then what consequences does that patio, dining patio, have for calculating FAR and all these other things on the lot next door? I mean, I'm just telling you, you know, we can write legal briefs about this and you can be litigating this and spending a lot of money unless you just throw up your hands and say, okay, do it. So I think I want to mention something about the certification. So, you know, for some things, like if you want to vote, you have to file, and you claim to be a 15-year lessee, et cetera. You have to file the actual lease agreement someplace. Certification is not enough. In this situation, I think another sort of side problem that's created is who's responsible for what. Okay, so if there is waste from the patio next door, if there's noise, if there's some other disruption, you can say, well, I'm the landowner of that lot next door, so it's my responsibility, but it's actually the restaurant's dining area. And that raises another question. Do you really care who owns the dining patio? You know, do you really, I mean, do you care if the lot owner next door builds it and owns it? Or does it really have to be built and owned by the person who owns the restaurant? Because now all of a sudden you have a situation where there's sort of two different structures, part of the same business, and you know, something's going on in one part and not the other, and I don't know, what are the police going to do, or what are who going to do, or, you know. So you may actually want to consider, possibly with the numbers scratched out in terms of financial compensation, you may actually want to consider that these agreements be filed with the city. It doesn't sound like there's going to be hundreds of them or dozens of them. It's not like people renting out their homes. It sounds like there's going to be a discrete number. And given the significant public consequences and other things that I've raised here, I'm not sure why the city wouldn't want to see the agreement, particularly if the numbers are scratched out, because the agreement, among other things, may divide up the responsibilities for things, and that may not be the way you want the responsibilities to be divided up.
Harvey, you get close to the end there.
Yeah, well, if there weren't so many issues with this, Mayor, you know, this is a junk ordinance, the way it's written. I'm sorry, you know. And the reason you're getting these comments are because we are left with all of these uncertainties and anomalies and non-definitions. And I'm raising these now. I think you would rather I raise these now than later on down the line, nobody's addressed them and there's a lawsuit, and all of a sudden you're spending a bunch of money litigating a lawsuit over what this stuff means. So I don't think I've been repetitive, and I don't think I've taken unnecessary time. I think I've been responsible to bring things to your attention that are missing. If I can look and see if there's anything else on a list that I have here. I do not see that. I will have a short comment on the 750 square feet when we get to that, because these numbers were, you know, they're in there for a reason. So.
Thank you, thank you.
Thank you, Mayor.
And don't forget, we would welcome anything in writing if you think of additional things. Oh, don't go back.
Thank you for saying that, but I'm not the city attorney.
Because we publish it, you know, embedded in the agenda.
Yeah, well,
that
we
way
need to do a better job publishing what the city puts out.
Thank you. Anybody, thank you, Harvey. Anybody else from members of the public who want to comment on this specific topic? If not, we'll close the public portion of that. Is there anybody that, based on those comments or any other comments from the public, that want to change their mind and abandon this and instead leave it to restaurants to go to seek a Board of Adjustment variance? I'm receptive to continuing the conversation. And I think at this point, Glenn's going to need to listen to the tape in entirety.
Yeah.
Anybody else up here?
So just for clarification, so if a restaurant does want to do, put a dining patio in a abutting lot, they still have to go through the full permitting process.
The permanent compliance process.
Right, so they're not going to be allowed to be building a 30-foot deck or something, right? I mean, is that?
That's not
well,
That's not addressed in the code.
yeah, we don't have anything that's, I mean, the,
permit of compliance only really addresses the ABCC requirements. It does not address size, height, limitations, anything of that nature. It would have to be created, and that's why I think there's got to be some more investigation in this, certainly as Mr. Schulman's points have brought up, and also I think direction from building and licensing of challenges that in unintentional consequences that have been met. You know, it certainly sounds like a nice thing to do, and I think it would bring, you know, added benefits to the dining scene in Rehoboth, but you don't know what else you're going to be allowing unconsciously in this regard. That's why, you know, I have some concerns with this. I want to see it through and I want to work it through, but I think there are some issues that we don't have answers to, and I'm very sorry that our solicitor is not here to provide some at least initial response. So, yeah.
yeah, thank you. And, you know, Harvey, I do appreciate everything you said, and I think that we need to address every point in there one way or another. You know, I think, what is it, Azura, what's the new name of them? Unwind at the beach. They have a second-story deck outside, and so this is a good point. You know, do we want somebody to be able to just abandon the ground level deck and make a second-story deck or something?
Well, and what about a rooftop deck on a building next door to you? I mean, that's a possibility. And is there anything wrong with that or right with that? I don't know, but I don't think those types of things are addressed.
Well, I'm a bit less diplomatic than my colleagues. I guess what annoys me about this is to have one of our citizens here who I respect opinion talk about work that has been presented to us as a junk ordinance. So I would just like to go on record to say, I'm not an attorney. I couldn't tell you if it's a junk ordinance or not. However, after listening to the very clear and simple questions that Mr. Schulman has raised, it annoys me on a level I cannot even articulate that this is in front of me at this moment. But I'm very, very glad that we're doing the right thing by starting in June for something that we need to vet completely, and we'll get there. Today is just an annoyance for me personally. So.
Very good. With that, we're going to close this topic and go to the next item of business, which is item B, new business. Discuss whether or not to amend Municipal Code Section 270-19 use restrictions of the zoning code specific to the 750 square foot gross area size limitation on outdoor dining patios for restaurants which serve alcohol. The support document embedded in the agenda is 270-19 use restrictions, and highlighted in there is a specific item that we'll be talking about today. This is an introductory discussion. It has to do with the 750 square foot limit per restaurant, which is a size limit permitted in addition to other limitations for the interior. I'd like to give some background and a reminder that the current zoning imposes a maximum size of 750 square feet for dining patios. That's patios on the premises of the licensed restaurant. However, currently, based on actions at our last meeting as a result of dealing with the aftermath of COVID, at our last meeting, we suspended the 750 square foot size restrictions for dining patios on private property. And again, this is distinguished from size limitations or any discussion of patios on public space, public sidewalk. We are specifically talking about on the premises of the restaurant, 750 square foot size limitation. Now, again, at the last meeting, we suspended the 750 square foot size restriction. What does that mean? Well, that means there's no size restriction. What does that mean? That outdoor patios on private property can be of unlimited size. Also, concurrently, we suspended at the same time restrictions on location of dining patios. We said they can be on the abutting property, they can cross the lot lines, but again, not on public space unless it conforms to the new policy regarding outdoor dining on public space. And then thirdly, we also suspended the requirements to obtain a new or an updated permit of compliance, and those extensions go through October 31st. 2022. So let's look at the timeline. The current size and permanent compliance suspensions expire November 1st, 2022. Earlier, we had talked at previous public meetings, I think 2 or 3 times ago, we talked about examining or re-examining the 750 square foot size restriction of dining patios at the end of summers when we were going to address it. But to me, that's problematic, waiting that long, because I believe the expiration date of November 1st will be here all too soon. Therefore, I believe we need to resolve the size restriction topic in time to allow for restaurants serving alcohol to know what the rules are, to apply for a supplemental dining permit of compliance, have it acted on by the mayor and commissioners, then have time for the restaurant to apply to the state liquor license, then have time for the alcohol commissioner to act on it, all before the November 1st deadline. And I'm not really interested in any more extensions, nor the suspension of the rules. And I do firmly believe that by starting now, By November 1st, it will be time to restore and clarify codes and conform to the codes. And that's what I want to start this earlier. So from now to November 1st, when that expires, it's about 4.5 months, which seems like a short amount of time, but if we agree to consider changing size restrictions, then we need to aim toward conducting a public hearing, because just like the last topic, this is a zoning issue. We've got to, at some point, vote to go to public hearing. Then we've got to conduct the public hearing. And that would take us likely into mid-July at the earliest, or mid-August if we need more time. And then that mid-August leaves the restaurant 2.5 months to apply for their liquor license, to have it acted on, have everything done and ready to go. So that's where we are. I certainly have thoughts on the 750. I have to admit that I'm nothing to admit. I'm just state the facts that I was not necessarily against the 750-foot extension to unlimited for private dining patios as of our last meeting during the COVID suspension. But to me, this is a totally different topic. This is when we get back to some normalcy. What do we want the size restrictions to be? What do we want our town to be? This is, I think, a very, very important topic. So I'd like to turn this over to the commissioners first, and then we'll ask members of the public to give their comment.
I just have a question for building and licensing, if I may. In the code right now, it speaks to the permanent seated dining area. How do you interpret that phrase with regards to the patio aspect? Is that?
Thank you, Commissioner. So what we have to consider is access ways as well as table spaces. So a full patio can't just be crowded with tables. You've got to be able to access those tables and service those tables. So you have to have service ways. So, you know, in a let's just say an 800 square foot patio or whatever, you can only fit a minimum amount of tables in there with respect to actually being able to serve those tables.
And if you'll help me remember this though, in doing a permanent compliance for patio dining, is there a seating plan required for that?
Yes, there is, Commissioner.
Okay. Thank you.
Welcome.
And again, if you read the highlighted section in the support document, the use restrictions 27019. It says the gross area devoted to dining patio purposes shall be limited to 750 square feet per restaurant, which area shall be permitted in addition to the limitation contained in 27019A4. 27019A4 has to do with size limitations of the main restaurant building itself. The sum of the the sum of the floor space devoted to permanent seated dining and bar area in any building shall not exceed 2,500 square feet, except that where a restaurant occupies space in a building also housing a hotel or motel containing at least 25 bedrooms, the area so devoted may be up to but not more than 3,750 square feet. So again, there is a size limitation of 750 square feet. I'm actually somewhat amenable to considering enlarging that a little bit. I absolutely positively would be against going to no size limit, which means unlimited. I think that would be a disaster for our town in terms of what it would do to our town in terms of noise and visuals. But I also want to remind everybody that, and if we change, I would prefer to make small steps. I think going anywhere above X 100 feet more would be potentially disastrous. But what I'd like us to keep in mind also is, if you recall, one of the restaurateurs came to us before and suggested that rather than a square foot size limitation, if we could possibly consider a limitation based on the number of chairs. And if you recall, my conversation with building and licensing and the city manager were inconclusive at that time. We didn't have enough time to research it, but we certainly can. It was trying to convert 750 square feet to a number of chairs. And at that time, my research, there's a restaurant up here that has a 740 square foot deck. So essentially that's 750. And I believe, if my memory is correct, they have, say, 60 tables or 60 chairs. So maybe that converts. I used another permit of compliance, which had about half the size, 375 or so, and doubled it and came up with also about 60. So maybe that has merit, and before we commit building and licensing time to do any more research, I would want to hear from the commissioners that this is indeed worth devoting a little time to. Maybe there's a hybrid here. There's an X square foot limitation and a table limitation that you can do either or, whatever serves you best. Commissioner Sharp?
Mayor, I think this question has already been asked, but I don't think we've ever gotten a clear answer. And since we're in the beginning stages of discussing this, have we ever come to an agreement or even a relatively good answer for why we have the 750 square feet in the first place, and what's the relevance of it? Why is it 750?
Well, I think we addressed that last time, and there was no answer.
Okay, because I did miss one meeting on that. So.
Paul, Susan, or Patrick?
I have always believed that there was a desire to have proportionality. And I say that because there was always a desire to limit the size of restaurants so that we didn't become, so that we didn't become a bar town. There are limits on bar area, 25% of square footage of the dining area, not to exceed 500 square feet. There were always, when the restaurant code was done, or like 91 or whatever, there were specific goals to have these proportions, and that's where I think it came from, because there was a limit to the size of the restaurant overall.
Well, and I'm so glad you mentioned goals, because to me, before we get to what our number might be, it seems logical to me that we decide whether or not our goals have changed. And if our goals haven't changed, if we have consensus that those are definitely how to guide us, then to me it's very easy to say, if these are still valid, if these are the things we still value, then maybe making a small incremental change would be helpful, or it may push us in the direction of, is it more logical to go to the number of seats or chairs?
Commissioner LeGree?
Matt, would it be easier for you if we said square feet than if we said 60 occupants?
It's easier from a calculation standpoint to be square footages rather than, basically what we do right now is let a designer or a design professional lay out those table spaces, and then we confirm access pathways and things like that. From that perspective, we're getting seating charge anyways, so we're looking technically at both of them. Again, probably easier from our standpoint to do from a square footage perspective.
I don't know that needs to be determined. If you like, if you like, if I nod ahead, we can further research that for the next meeting and take a look at an opportunity. Because again, we could specify that square footage maximums change the number of chairs, but we can also have a hybrid where one or the other. Because if you recall, the restaurateur that asked for consideration of number of chairs was so that they could specifically spread out and social distance their clients. So that's one thing. while I've indicated I'm interested in considering expanding the square footage a little bit, I do have a pause in that I absolutely would not go unlimited, as I said before. And I think part of it has to do with the noise component. Part of it has to do with an aesthetics component. Right now we have restaurants. Right now we have restaurants that at the entrance to the city that have a huge parking lot, and they've got another parking lot at the restaurant, and there's another one that has a huge parking lot, and there's another one that has a huge parking lot. What this does is, if we went unlimited, would facilitate perhaps that restaurant converting all those parking spaces to dining areas. Now, there's got to be probably some logistics in it. They can't handle too many tables, but it still would be the opportunity to be able to set up outside, dismiss all the parking, and do that, because restaurants have no requirement to furnish any off-street parking. We know that from Dogfish Head, for instance. So there's a kind of great consideration on my part why I would very much steer clear of unlimited size restrictions.
Yeah,
Anybody else?
I would say I don't think any of us are for unlimited, but I do think that one restaurant you're speaking about, what was compelling to me was not only the expanding the distance between some of the seating, was also that they said responsibly, our kitchens can't handle us to cram in a bunch of people, so we're not going to do that as well. So I think the responsibility of the business, we need to give them some credit too, that they're not just going to crowd these spaces with seats and then not be able to handle the patrons.
No, but I can also see the restaurant expanding their condition, their kitchen,
right,
in order to accommodate more.
Well, that's why I think maybe it is a hybrid of a number of seats, or with the tables or the spacing. People don't want to be right on top of one another, right?
But again, we have a different option. We could just leave the 750 square feet alone, and also convert that to 60, if that's what the number comes to, 60 chairs, either or, which essentially is changing the zoning code, but it remains the status quo size-wise, essentially. The other option we can do, instead of going from 60 seats, we can go to, pick a number, 900 square feet, and go to what's a commensurate increase in number of seats. Add another seven seats or something to it. So there's an option to do that also. But I really want at some point to hear from the public on what they want, because again, for me, it affects the future of our town and what we want. And I'm very comfortable with what we've got right now.
And I'd like to hear from the restaurant owners, hear what their thoughts are too.
Anybody, before I go to the members of the public, any further comment up here?
Just one comment. When you talked about expanding, the kitchens to meet the needs of the diners, when we revised the restaurant code in 2016, that at that point in time, the maximum restaurant could be 5,000 square feet, and that included dining, kitchen, hallways, restrooms, all of that nature. We made the change in 2016 to change that so that the dining area had a maximum of 2,500 square feet, but you could expand kitchen, restroom facilities, hallways, storage, everything beyond that. So if you had a 10,000 square foot parcel, it could be, not that this makes economic sense, but it could be 2,500 square feet of dining and 7,500 square feet of restaurant, kitchen space, storage space, what have you. So there is that opportunity, because of the way the code currently reads, that you could expand your kitchen, storage, whatever, to meet the expanded dining needs of the tables and additional space for outdoor dining, what have you. So just to, there is that change was made back in 2016.
I could also anticipate a scenario such as this, that restaurant expands their outdoor dining to 1,500, so they double it. They either expand their kitchen or maybe they're able to accommodate that. But during the summer, they focus on the 1,500 square feet outside because that's all they can handle. And then in the wintertime, they focus all on the interior. So, I don't know what the different scenarios can be. Again, I look at what are the aesthetics of what can be done outside and what's the noise levels, how would they be affected, et cetera. Anybody else before we go to the public? All right, we're going to go to the members of, thank you, Matt. We're going to go to the members of the public. If you'd like to say anything, please raise your hand. And we still have to use the lectern, Joe, and I'd like you to state your name, your relationship to the city, and then give your comments, please.
My name's Joe Maggio. I'm one of the co-owners of Port 251. I've been here since '96. And I want to thank you all for just taking a look at all of this. And I didn't expect to say anything today or even comment on this because we are on private property and we've gone through the process of getting approvals through the city for the additional space. But I want to remind everyone that this patio space that we're talking about, this extra space, came out of a public health need. I mean, we just didn't come up with this. We do want to have social distancing, and that has helped us. And the restaurants have taken a beating for this is the third year that COVID is not over. So I want to just make that point. I think everyone should remain a little flexible to see what the outcome of the next 6 months is going to be, because I don't really think this is done yet, and we should be prepared for something else. And if that's private property, I mean, we lease that property on the point. I mean, we have to get permission of a whole cadre of people to do anything. And right now, we can't even staff the restaurants in this town. We're dealing with a lot of things that all businesses are dealing with right now. But the city has been great and gracious. We do appreciate the extra space. And that's really all I wanted to say about it. But I would just say try to remain flexible to see where this ends up in the future. Thanks so much for.
Thank you. Anybody else? Somewhere? Are you somewhere? Oh, yes, come on up. You need to refresh my memory on who you are. Your name and relationship to the city, and then we'll hear your comments, please.
My name is Megan Key.
Yes.
I'm born and raised here, and I have built my businesses here. So I have Houston White on the avenue, Fable on Baltimore Avenue, and Dalmata, that, to Joe's point, is still closed for the season because we don't have enough staff, which is a real bummer. So the outdoor dining, I just wanted to, there were a couple things that I heard, some commissioner statements that I just would like to address first, if it's okay.
Megan, would you speak a little more into that microphone? They're almost
sure.
heated. No. Yeah, that's what we want. That's great. Yeah. That's what we want.
So one of the things I listened. I had to go pay the meter, but I listened to you diligently. And one of the things I did want to, you gave me an opportunity to state that I personally don't know of any restaurant values that are at $1.5 million that don't own their property. So I just wanted to state that if you do allow adjacent patio spaces, that's not a real number. So I wouldn't be too concerned as a public if there'd be financial retributions if something was removed. If anything, from our perspective, the amount of money it takes to enhance a patio. When COVID came and I had no money at all, and I knew we had to go outside just the little bit of what I did at Houston White, which is like some plants from Home Depot, umbrellas, tables, chairs, still cost me almost $10,000. And I had no money, but I had to do it because that was what people needed. So I wanted you guys to just sort of consider that when people do go about looking to enhance their businesses, and I'm very nervous, sorry. When they go to enhance their businesses, it is a huge expense on the restaurant when we do make the decision to go outside. And there are no guarantees, especially with the weather and the rain. The extra square footage would be greatly appreciated because if it does rain, then at least we could have larger umbrellas and spread out even further. I know that's a silly thing, but I have massive umbrellas in the event that it does start to sprinkle, because otherwise, on a tiny little patio, people just leave, and you know it rains here quite a bit without any warning. The other thing I wanted to just touch upon was the parking lot comment about how there may be concerns about restaurants converting private parking. This is something I think about a lot as a resident. What if it became a building? You know, there's no limitations on what that parking lot could become. If you guys do want to put controls in on how it would look and how the town would feel, I love that. I like keeping Rehoboth. But when we talk about things like a restaurant possibly taking a property that we spend a lot of money to rent and trying to make a business and jobs for people in the area, you have to consider that, yes, from your perspective, it looks like private parking. But from my perspective, it looks like it could be a line-to-line office space with no parking as well. Or no, offices require parking, but like a line-to-line restaurant, again. So I wouldn't look at like these parking lot adjacents as possibilities or problems to remove parking from the area, because it could become anything, whether it could be a patio or a line-to-line building. You can't really look at it as a parking solution. That's my comment I wanted to make there, if that's okay. And then finally, I just wanted to say thank you for considering increasing the patio sizes. For me in particular, I haven't made the efforts because I haven't had the time or the resources to really fully commit to the liquor board, because I think, you know, I opened a place in Lewis like a dumb crazy person in the middle of a pandemic. I love it, but the permanent compliance, when I look at how I can work with the patio space I have at Houston White, which is something I never considered before the pandemic, I realize that when we do get out of this, and to Joe's point, there will be health concerns probably for at least a decade. We're going to see older people who, I don't know if it will be COVID related, but I just think the platform of how we live is going to be altered. I see it in Lewis a lot. People have no desire to come inside. And I don't know if it's just different town to town, but it's interesting for me to have these two perspectives, because I don't know how long that's going to go. And for example, 2 days ago, or yesterday, I don't know, every day becomes a week, none of my beautiful restaurant in Lewis was seated inside. And fortunately, I have a nice deck. I'm at the Buttery, and I have a little front space of a patio. But if I didn't have those two spaces, I maybe would have had 2 people dining inside my restaurant on Sunday, Sunday, on a weekend. And that's something I think we're going to continue to see. So if you guys want any help at all, like input from people like me who would love to help create a landscape that fits the town's authenticity, what the town residents would really like to see, to help breed a longevity for both of us, the residents. I'm a resident and a business owner. I would love to contribute my energy. That's what I'm here to offer, if that's okay.
Thank you, Megan.
You're welcome.
Thank you very much.
Mayor,
And I would offer that maybe some of our Lewis patrons ended up coming to Rehoboth Beach instead. Commissioner Sharp.
I don't know if it's appropriate, but the couple of business owners that we have heard from today, can they answer a question? If I pose them a question, is it appropriate that they could answer it?
Sure.
I guess I'm wondering.
I'm getting a nod.
If
You
it's
would need to
okay?
come, to answer it, you need to come back to the lectern, though.
It's a very simple question. I'm just kind of curious how many additional square feet, if you had it, would be advantageous to your restaurant?
Well, for me,
Yes.
for example, Houston White,
Yes.
I have to look at my diagram. It would be advantageous for me to use all of it. And the reason I say that, I know I have.
But what is all of it? Give me just, and it's just totally off the record, just a ballpark.
Joe, do
Is
you have
it
an answer
is
to
it
this?
250 square feet? Is it 100 square feet? What is it?
Well, forgive me. Let me interject something
Okay.
here first, okay?
Yeah.
One is when I talked about restaurants with parking lots, that a concern about the fear of expanding, getting rid of all the parking and making it all dining, okay? That is provided legally they can do so.
Correct.
Okay, because if you remember, we've had multiple conversations prior to this, previous, where we have said, for instance, if you own a restaurant and you have a dwelling upstairs, there are certain criteria that require you to have off-street parking and access to that off-street parking, which means for some, they're not able to put dining in their driveways or in their carports or in their.
Yeah, I'd love
thing.
to talk about
so
that
I want to
one.
make sure we understand it. So certain restaurants, we can ask them that question, but certain restaurants may end up saying, I physically don't have any extra room on my property.
And maybe I should rephrase my question. In your current environment where your outdoor dining currently is there some additional space that you could use? And if so, if it were just that area, just give me a sense of what it might be.
Sure. So, for example, if you're familiar with Houston White,
Yes.
When I built it as Bramble and Brine, my driveway space, it looks like it's a full driveway, but there's actually the variance you need or whatever you need, the walkway to get back to if we were to expand outdoor dining in the back. I can go to the side and back, and I have done that throughout the pandemic. To Joe, again, I never fill it consistently. It just sort of floats in and out for social distancing, and I don't have the staff or the kitchen space to accommodate it. But what I would love to see is the ability to, again, spread out. And I would say it's probably around 1,200 square feet in my L. To my defense as well, I've only had one person call me about any noise because there was a big birthday party singing Billy Joel.
So does that mean an additional 1,200 square feet,
no, that
or
would
just
be
the difference?
That's probably about what I would be at Houston. But for me, the one that I actually would like to discuss is Fable, because at Houston, I would love, if I could afford it, I would make it like a 3-season room because that makes better sense for what that concept is. But at Fable, I do have some space in front that is private property. And any of you have been to France, you know, like the street part, you know, it's very French when you sit on the sidewalk and you people watch and you have your coffee. I appreciate that the city has allowed me to use this for the past few years, because before it was just plants. I personally believe it enhances the street when people walk by. I only have 4 little 2-tops and they're on my property, but I don't know the code well enough. I was told that I wouldn't be allowed to use it because it wasn't large enough if I wanted to apply for that permanently. And I don't know why, other than what the code states, so that's something that I'd like to ask in the future when that comes up. I probably have at least 6 to 8 feet in front of the property where I have my tables. But I think Howard had mentioned that I wouldn't be able to apply for that permanently, and I would like to.
Well, maybe Matt or Howard can meet with you again, because there are certain size restrictions and what you can and can't do, even on private property.
So I have a question. Am I able to ask for a variance for those few little tables? Is that like, because I heard the variance word for the adjacent properties.
And the answer is no. There's no process for that.
Okay, is that something
Right.
we could put on an agenda in the future?
Thank you.
If it is, we'll let you know.
for
Joe, I
helping me.
cut you off. Did you want to contribute? Thank you very much. Anybody else? Any other members of the public? Mr. Diefendorfer? Again, we're on the topic of 750 square feet. Should it be left alone? Should it be increased? Should we offer a hybrid where we offer a limit based on number of chairs, et cetera?
I understand. Yeah, Dave Diefendorfer, 113 Newcastle. I just want to say I am in favor of allowing some expansion, whatever that number may be. I'm also in favor of allowing spreading tables out and whatnot. But the one thing I want to say that we have to think about is I'm a licensed fire protection engineer, and sadly I don't remember this because I'd have to go out and dig out my books. But you can't just arbitrarily pick a number of seats. I want to have 60 seats, I want to have 30 seats, I want to have 40 seats. It's life safety and egress. So depending upon what the patio is going to look like, people might say, well, it's just a patio. Well, if you have a wall around the patio and you put a rooftop above it or whatever with plants, so there is life safety things you have to think about with that. So just can't pick a number, but it's a good thing to do. So.
Correct. Thank you. Matt, do you want to contribute add anything more to that? I mean, we know we've had discussion before that even on private property, you have the table limits, but you also have certain fire restrictions that require a minimum aisle space and everything. And that's what's tripping up a lot of our restaurants, that there's just not enough geography in front of their building, whether it's public space, which we're not talking about today, or even private space.
Thank you, Mayor. Yeah, Mr. Diefendorfer is correct. I mean, there's access aisle widths and things like that, as I was speaking to, not only for service to those tables, but also for the emergency egressing of whatever occupants are inhabiting that area. Thankfully, in most situations, they're not entering the building to get out of those areas, which is against the code anyway. But yes, we do have to look at exit aisles, safety concerns with moving people rapidly in the event of an emergency. And I'd also like to add that from a design perspective, we're seeing a trend in the residential portions of outdoor living. We see a lot more courtyards, we see a lot more outdoor kitchens. COVID has presented to the businesses now and said, hey, we want to move things outdoors. And I know of nothing has been applied for yet, but I know several designs that are in the process of completing that are looking at addressing a lot more outdoor stuff, if you will, whether it be sales, restaurants. The design trend is definitely moving to a more outdoor scenario.
Well, again, we've got zoning codes that may limit that.
Correct.
And everything. I think that brings up a good point. When I was talking earlier about the 750 square foot limit, translating for at least 2 restaurants into about 60 chairs, there's I think it needs to be reiterated that there is a formula for coming up with that, because you can't have 750 square feet and have 120 chairs in that area. It just physically, it may physically fit, but you wouldn't have any aisles or walkways or egresses or space between your barriers and things. So there's a lot to be thought about in this process. Go ahead.
I was going to say 2 other things, or question while I have you. If memory serves me correct, when we were reviewing the 2016 restaurant codes, doesn't the health department also require that if you go over a certain number of seats that you have to increase your restroom facilities?
That's correct.
So even if you're, is that inside, outside, or just totally service?
It would be the total building load for no matter what scenario, whether it be indoor or outdoor dining. The inclusion of more square footage, to say for an existing patio, we would definitely have to take a look at the number of fixtures that service those occupants.
And that's state health department?
That would be, yes, and building code as well.
And also curious, just on the question of seating versus square footage, what have you, how do you address that enforcement-wise?
So from an enforcement perspective, thankfully we have the permit of compliance. So once we approve that application, it's solidified in our documentation. We go out and we re-inspect, occasionally go out and look at the control, basically, that we have put in place by permit of compliance, and just make sure that they're adhering to that permit.
But doesn't our code currently reflect that a review of the floor plan annually?
It does.
Thank you.
Yes, you're welcome, sir.
Thank you. Thank you. Thank you, Matt. With that, any further comment? Remind me your name again. Mr. Schulman, come on up. Come on up. You did, I hope you weren't bluffing, but you said earlier you were going to have a short comment on this.
Short comment. Well, after hearing all of your comments.
Go ahead, go ahead.
Actually, I thank the prior speakers because they gave more credibility to some of the things I would have said, because they're more knowledgeable. But we have to remember historically, what is a little bit troubling is to hear this discussion and no one really know where these numbers came from. I can guarantee you they're somewhere buried in the minutes of the city when these things were developed. The history for many years was always a balancing act between how much bar space, what about alcohol, how much noise, you know, how much cleanup and waste outdoors versus indoors, the safety concern, thank you for mentioning that. So to sort of ask the question, is 750 feet the right amount? You have to do what Commissioner Sharp said. You not only just ask that question anew, but find out where these numbers came from. Because I can guarantee you, this debate has been going on for 30 years, and the ordinance has been iterative, and the numbers keep changing. So please, tell the public where in the minutes. I'd look at 3 sets of minutes, but I don't want to read personally as a citizen, 30 sets of minutes where this is developed. So please tell us where this came from. Secondly, as the mayor said, I do think it's a good idea, complimenting you. It's a good idea, as the mayor said, it's a good idea to look at a combination. And it really, I mean, this is very common, but you have to put, no more than, or you can't say just 750 square feet or 60 chairs, because what does that mean? It's sort of no more than the greater of, okay? So think of some number of what's a good number of outside seats, because remember, the problem here is not just the aesthetics, it's the noise. And as many of us know, there are noise, the noise problem becomes more acute when you're closer to residential, even though they're only behind you or whatever. So think about, what's a reasonable number of people outside and how much noise and trash and other things that would create. And then say, and how much space from a safety perspective each seat should take. And you don't want to say 60 seats or 750 square feet, because someone may only have an area of 250 square feet, and you don't want them jamming 60 seats in there. So you have to put it, no more than or no less than, or you have to come up with some sort of relationship that creates a number that's tied to space. And I do think that's a good idea. Thirdly, I think as Joe Maggio said, we don't, and as, I'm sorry, I don't remember your name.
Megan.
Megan. We don't know where all this is going, so, and the point about flexibility, you may go through all of this and come up with a number, and it might be great now, but, 7 months from now or next spring, it may be the wrong number. I know you want to get this settled, but, there probably isn't anything wrong with extending this, given the uncertainty and the flexibility that's needed, because you don't want to go through these arguments again next year and, and advertise an ordinance with a difference in square footage. It just duplicates the process and the cost. Where suspension, it's not a great thing because, it creates the potential for abuse, but it may be better in the long run. Another point, remember that for commercial areas, I believe that FAR includes lot coverage that doesn't have a roof. So, you know, whatever the expansion is for outdoor, depending on, you know, I don't know what they're putting on, you know, are they putting actually a deck above ground? Is it just on the ground? But, you know, how does that tie into the whole notion of what FAR is and the relationship between FAR and size of the business activity on these lots? And then I think the last point I'd make is that what Commissioner Gay said, there was, I think you'll find somewhere in the history, a sense of proportionality. And, you know, think about this. You know, one of my neighbors for a long time owned a great restaurant in town until he sold it, which was the back porch. And I can tell you, I loved eating outdoors, except in the middle of the summer when the humidity was awful, and everybody said, God, I hope we can get an indoor seat. So, and I think some of you, I may have met in that situation. We're waiting for an indoor table. You know, we don't want to be outdoors. So it's not, you know, in the public health climate we have today, people may say, well, I don't care if I sweat, you know, but this whole balance between indoor and outdoor is more than a pandemic and health thing. You know, it's weather related, and yes, in the winter, on some nice days, people want to sit outdoors, but mostly indoors. But in the summer, don't assume that everyone is gonna want to sit outdoors. So I'm glad you're considering this, but unlike the first item where I personally am supportive of the notion of doing that with the right limitations. This one, I don't even know whether it's the right thing to do because I just don't know all of the history and all of the concerns. So thank you, Mayor. You've done a wonderful job bringing this discussion along, and I want to compliment you a second time in my presentation.
Thank you. And you must have missed the memo. When you compliment, you put your mouth right up to this thing. Carol Everhart, please. And conversely, if you're going to criticize, then
Step away as far as you can.
Carol Everhart, Rehoboth Beach, Dewey Beach Chamber of Commerce. I just want to, for the record, make sure that you know that anything that can be done to, you know, we had that clean, safe, friendly, and I can tell you this outdoor dining could not be friendlier. So whatever can be done, the visitors love it, the residents love it, the workers love it, everybody just loves having it. So anything that can be done, and it sounds as though something that, I'm not an expert in this, but it certainly sounds like a compromise in this, something that has both size and seating capacity would be something that could be considered. So I just wanted to get that on the record.
Thank you, Carol. I intimated before that an unlimited size, I believe, would violate friendly based on the noise thing. So I think there's got to be some limitations. And frankly, I'm very proud of this council up here overall with all the suspensions that we did during COVID, with what we've enacted, extension of the suspensions. I think we've done a phenomenal job and demonstrated our support of the restaurants overall.
I agree, the whole business community, because it's just been, you've had a lot of balls in the air to juggle. It's just been a tremendous effort, so it's appreciated by everybody.
Thank you, Carol. Walter, was there anybody else in the public that wanted to speak? If not, I thank you. So for the commissioners, shall we carry this over to the July workshop. Hopefully then, maybe we can find out about that 750. I know that everybody's looked for it and hadn't had any luck on it, but if not, then we'll continue this discussion, and we'll look a little further into this hybrid system and continue discussion then. Is anything, Commissioner Bennett?
Would we also task the city solicitor to perhaps fix the ordinance based upon citizen comment today that it seems to not be adequate? So I think
that's the other
well,
one.
that's the first one.
Right, but I mean overall with moving this forward.
Yeah,
right?
oh, yeah, definitely. He's going to need to look at everything and react to our comments as well as the public comments. Absolutely. So we'll see if we can advance it a little bit at the next meeting. Thank you very much. With that, those that are here for the restaurants, you're welcome to leave. You don't feel obligated to stay. Although let's see, our very next item is new business. Again, we are deferring on no left turn, and we are deferring on 1 Grove Street, unfortunately. Passing those off till the July workshop. If it has to do with those two topics, I can't let you talk. So 1 Grove is not on the agenda till July workshop. All right, Mr. Good? Well, I'm sorry, but I've deferred it on the agenda, and we cannot legally talk about it today. If you hang around till citizen comment, I'll let you offer. Yes, sir. With that, we're going to go to the next item of new business, which is present proclamation recognizing June 22 as LGBTQ Pride Month in the city of Rehoboth Beach. This is something I wondered if could just be done forever in perpetuity. To make a proclamation that says June and forever. Should be recognized as this. But instead, I think in the atmosphere we live in nationwide, that it bears repeating on an annual basis, at least for now. So I have a proclamation I'd like to read, a proclamation by the mayor of the city of Rehoboth Beach, Delaware, declaring June 2022 as lesbian, gay, bisexual, transgender, queer, and questioning LGBTQ Pride Month. Whereas our nation was founded upon the declaration that all people are created equal, that life, liberty, and the pursuit of happiness are among the inalienable rights of every person, and that each person shall be accorded equal protection of the law, and whereas everyone should be able to live based on gender identity or sexual orientation without fear of prejudice, discrimination, violence, or hatred. Whereas on June 28, 1969, patrons of the Stonewall Inn in New York City rose up and resisted police harassment that had become all too common for members of the LGBTQ community, and this date is celebrated as the beginning of the LGBTQ rights movement in America. Whereas the LGBTQ community has made great strides forward, but equality, inclusion, and acceptance have not yet been fully achieved. Whereas one of the guiding principles of the city of Rehoboth Beach is to foster diversity of the residents and and visitors to the city. And whereas Rehoboth Beach is home to a vibrant LGBTQ community, which greatly contributes to the social and economic vitality and character of the city. Now, therefore, I, Stan Mills, Mayor of the city of Rehoboth Beach, Delaware, on behalf of the city commissioners, do hereby proclaim June 2022 as LGBTQ Pride Month in the city of Rehoboth Beach, during which time we will fly the pride flag, and we encourage all residents and visitors to respect and honor the LGBTQ community, celebrate and build a culture of inclusiveness and acceptance, commemorate progress toward justice, equality, and full civic recognition for LGBTQ persons. Join us in the fights that remain to be won, dated the 6th day of June 2022, signed Stan Mills, Mayor. I'm very proud to read this for the second year in a row. Very proud to have the gay pride flag flying out in our parking lot there with the others. So thank you very much with that. That's on behalf of the commissioners. With that, I wanted to go to, and we're going to put something up on the screen there. We're rounding the corner here. And I'm not going to use Air Media. He's putting it on the lectern screen instead. What is bigger? I can't see a plus. You'll see. This is a little housekeeping thing. I'm not going to spend a lot of time on it. It's more for the commissioners and the chairs of committees than anything. But I feel we need to remind everybody that we have certain policies that have been adopted by resolution, in which essentially carry the force of law. And so we want to remind everybody. In the support documents, you'll see an illustration of a formatting policy that all the documents that we bring forward have to be of a certain format. As you can see on here, there is essentially a header up the top with the date, a version number, an author, the subject describing clearly what the topic is, and then a presentation date. This is all for clarity, and I repeat, the intent of this was generated years and years ago when the commission up here was considering different amendments to some proposals, and the amendments were literally being updated 2 and 3 times a day. And so we would go from version 1 at a public meeting to version 6 at a public meeting to version 10 at a public meeting. And we needed to find a way to monitor that. And so out of that was born this policy. The essence, again, is here: date, version, author, subject, presentation date, continuous line numbers beginning the end. And there's a description. Again, I'm not going to go over with it right now. But we can go over it with you individually if need be. You got the date of a document. You've got the draft watermark that should be on there, the authors or sponsors, the version, the titling of the document, the date it's expected to be discussed, line numbering, page numbering, a synopsis at the bottom. And then also, as you change this from version 1 to version 2 or updating to the next version, we'd like to see a red line version that clearly shows what the changes are from the last document, what the deletions are, what the additions are, what the addendums are, preferably in red line, which there's a certain convention for that. Typically blue underline has to do with addition. Red strike through has to do with deletions. And then also additionally, we'd like a clean version so that everybody can see what is being proposed, but what does it look like if all the items are and proposed edits are accepted. So I'm not going to go through the rest of that. My version isn't even perfect because you can see I left off the word draft and added it by hand after the fact. So that's one. So again, if you would see me after the fact, okay, I want the next tab over at the top. Here? Here you go. That's the next one. All righty. So we've got the next. The next is a sample of a report for a committee. I would like our committees to more formalize their reports that they are presenting to the commissioners and to the public. And the essence of what we're looking for in a report is to identify the topic, offer background information, identify the concern of the problem, identify the objectives. I reiterate background information just because. Identify the evaluation criteria. Report on any data collected, report on committee analysis. What did the committee come up with? What are the pros and cons? Surely there's got to be good points and bad points or questionable points on implementing something new. Report on make recommendations. Of course, that's the whole point of the report. And then perhaps in there, how to measure success of the implemented recommendations. Again, this is a sample report. Here's how you would add such things. And this is not by any means to be complete, and it's not definitive. You can add to it, edit to it as you wish. But again, it hopefully will give you a framework in what you are presenting to the commissioners and the public so we can better understand your recommendation and we can better understand how to evaluate your recommendation. So again, you could look at that, call me if there's any, contact me with any questions. The next item here is a little PowerPoint I put together very quickly. This is something Ann and I and Linda worked together on. And this is, we put a lot of hard work, all of us in the chairs that do formal reports. And we want to share those reports with the other commissioners, want to share them with the members of the public, but in particular, want to share them with future chairs, because there are topics that we've talked about before that have come up repeatedly on committees that have already been talked about. And we thought that these ought to be archived so you can go back to them and look at them. And maybe have a starting point for your discussion. Or you even look at it and say, is the discussion worth rehashing again? So this is more for, as much for you as members of the public, that you start off by going to the city homepage, cityofrehoboth.com. That'll bring up the home page. On the right corner center, you'll have the legislative portal there. This is the legislative portal. This is how we get into the portal with all our meeting agendas and minutes and documents. When you click on that, it takes you to the home page of the legislative portal. You click on meetings. And from meetings, you'll come up with a list underneath that will have all your commissioners' regular meetings, commissioners' workshop, commissioners' special meetings, boardwalk, board of collections, boardwalk and beach committee, as well as all your other committees. You can see down here that under boardwalk and beach committee, we did this for. So I can't read that far. View. Archive Boardwalk and Beach Committee reports. So you click on that. That'll take you to the next page of the archived reports. And I'm going to put my glass. Hold on, I want to try to read this thing. Okay, from the there are reports starting at the top. These are all Boardwalk and Beach Committee report on budget recommendations. Consider a report on considering rebuilding after a catastrophic event. What do you do? Report on bicycle routing on and off the northernmost section of the boardwalk. A Boardwalk Committee report on specialty mats for dune crossings. A report on bicycle mapping. Report on considering restroom attendance. Report on waste bins on the boardwalk aesthetics. Report on considering a PA system on the boardwalk. Report on safety video camera use on the boardwalk. Report considering emergency designated lane on the beach. Report on public restroom amenities and changing room report. Report on public restroom amenities, etc. This is the only committee that has reports. That's only because they are ones that I was able to retrieve in my own personal archives while chairing the Boardwalk and Beach committee, and I wanted to share them with you and ask that for in the future for substantial reports, not little things that need to just be witnessed and memorialized in the minutes, but more formal reports, that they be done following the format template and the report template, and be shared with Ann to put on there. This also shows an additional method that you can look through here. There's an alternate method to be able to access these reports. Are there any questions? Yes, sir.
Nowhere in my job description does it say that I need to be a secretary, a typist, and a file clerk. It just takes time for, I don't type well. I don't even know how to format. I don't know how to do red lines. I have a computer that has a black and white printer that goes with it. And that's a lot of time you're asking. I know how much time you put in making these reports. And these beach and boardwalk reports are far and away more extensive, more complete, and huge, bigger than any other reports. When I give a report at a commissioners meeting, I want to report on what I think was the most important part of our meeting or a topic or whatever we did. And I don't expect the public to go back and read these reports. I don't think they do. I don't think they've read yours. I wonder how many of the commissioners sitting here have read the beach, the boardwalk and beach reports that you filed in the archives on the 8th of April. I mean, there's a lot of information in there, but it took you a lot of time to do it. Here we are, we're 6 commissioners and the mayor. We don't even have an office in this building. It's an $18 million building, and there's no place for the commissioners to go. All I have is a mailbox. I don't have secretariat support. I don't have typing support. I don't have any other support than what I do myself. And we've had 30-some meetings since January, and that takes a lot of time if a commissioner is supposed to do a good job, and you're just adding more time. This is boilerplate stuff. I've done basic research, and this is even beyond that. But I understand why you think it's important, but it's a lot of extra work.
Well, as far as the format policy, that is adopted by the commissioners. As far as the report policy, I don't know if that's adopted by the commissioners. It's not adopted. So you as chairs can choose to do whatever level you want. But this is something I desire, that if you do a formal report, not minutes, I'm not talking about minutes. If you do a formal report, then I'm going to ask Ann to embed it in there. And you can choose to dismiss me all that you want, and that's fine. But this is something I find very valuable because we keep going over things in the future, and I believe in the future, future chairs ought to be able to have access to these reports so that they know aren't redoing topics, because redoing topics consumes our time. It consumes the staff time. And I don't want to be redoing things that have already been hashed out sufficiently and put in front of the commissioners and either already rejected or already accepted. So again, you can do what you want. I'm fine with it. You can ignore all of it.
Well, I understand
but you know, for Commissioner Sharnowski, for instance, asked to have no left turn and One Grove put on the agenda, and I asked him to do formal reports for me so that we can have background material and information on what we're analyzing that's brought in front of us, because otherwise we don't have a clue unless we watched the street and transportation in our city ourselves and took notes. And so I think it is a reasonable ask, but it's not a dictate.
Well, I understand the formatting requirement is a requirement. And I will try my best, although I don't know how to do red lines. I just learned how to number, and now I see this whole thing is numbered, So I can do that. I thought the numbering started with the narrative. But it's just a lot of extra work for a commissioner.
I don't see it that way, but you,
I understand.
I disagree with you, but that's up to you.
Let me ask a question and also add something here. First of all, if an electronic template could be provided to us, then where basically, Jay, you're just filling in the blanks, I think that would certainly make it a lot easier. Because when I've gone, even to do the tree ordinance, I found I have to go back and find something that's the format so that I can copy it. And it does take time. And I think the sections within the report format here could be onerous to somebody who's not thinking of it that way. But if you have a fill in the blank, it would make it easier to do just that. So I would like to think an electronic template could be provided to us for use if the format is important. But the main comment I want to make is about the archiving. And I got to tell you, ever since this database we acquired it, it's great. I think the whole portal, the Civic Web, the Document Center is amazing with the organization and the amount of material that it has. And I use it every day, and I don't know what I'd do without it. And so I am glad that there is an effort to archive these reports, because I know what you mean. Otherwise, they're lost in the shuffle of attached documents, and you have to remember when it was said to know how to go back and find it. So I think it's wonderful to archive them. So my question is there going to be an effort to find all the other committee reports from the last few years and put them in the archive, or Beach and Boardwalk just going to stand out as ahead of everybody else because you know where they are?
Well, I was going to send out a memo to the chairs to ask them to go back 5 years and see what they can find, and again, on a volunteer basis. And in terms of the template, I've sent that out many, many, many times over the years as new commissioners come on board. Basically, it is the same thing that's on your screen as a Word document. I mean, there's only 12 things on there that form the thing, so.
I've done review reports for the tree committee, and I haven't necessarily used that format because I don't know that I've seen it. Maybe I lost it. I don't know.
I made my own format for minutes because.
Right. Well, that's different.
That's legal.
Minutes, yeah. But I do think it's I do think it would be good to archive reports because good information comes forward in the committee reports. But I think we should not. It's not just going forward that we should make an attempt to archive the ones that where work has already gone into creating. If it doesn't follow the format.
Are you going to archive reports from former commissioners? That's my struggle. I inherited a committee that's done 0 reports. And for me to go back 3 years and to do all that work.
You're talking about minutes, I think.
Well, then there's no reports, there's nothing.
If there are no reports, then there are no reports. The reports are totally, volunteer, right? We don't have to do reports if there's nothing.
But you're not asking us to go back and watch meetings and.
Oh, no, not at all, not at all. This is a separate effort than
going
requesting
forward.
past minutes.
Okay.
And I have to admit, even my committee is backwards on, short on having provided all the material she needs. So I'm going back to it. But no, this is specific reports. Has nothing to do with minutes.
Okay.
This is something that's substantial. If you follow through on a dog park, I would think that rises to a level where it ought to have a formal report with certain stuff in it. Here's when it first came up in years ago, and here was the result. When it first came up in front of the Animal Issues Committee, 5 years has gone by. We have decided to review it. New material that came up equals this. Old material, there's agreement with that, whatever.
Okay.
But that, to me, that would be a formal report so that in 5 more years, in 2028, when the Animal Issues Committee has been handed off to the new chair and they decide to look at the animal,
they get railroaded to ask for a dog park after it's already been argued 15 years ago.
You
right.
got it. So
I get it.
So anyhow, I think we've gone through this enough, and I will follow through. And again, it's volunteer. Do what you like, contribute what you like.
Well, I'm going to continue with minutes the way I have been doing them, and I don't know I don't like to see minutes denigrated because they're important and they're critical. And I go back and read them a lot, and I watch the stream. The streams are just incredible to learn the background of a topic, more so than anything I access.
And the minutes are already archived, you know, they're already,
You can
that's
always
one of the
go back
great
to the
things of the database. It's there by committee, it's there by time, it's, you
But
know,
if you want to find a specific topic,
right, exactly.
you can't do
I
it
get it.
without
I get it.
perhaps a word search or something.
Also with the research, if it doesn't go back past 2005, because that's when I started, that's how far back I've gone with the actual agendas, the minutes, reports. I have over 13,000 documents in that document center that I've put in there as far as ordinances, resolutions, and things of that nature. But I do want to let you know, I also have to, I am required to have minute books that may house your reports.
Right.
Prior to that date of 2005, there may be reports in those minute books.
Correct. But this process is where you put your finger on a particular topic within a committee in a second and be able to access it. And that's my desire. So yes, there's a time limit. I'm not trying to go back to 2005 to do this, but hopefully anybody, and there may be committees that don't even have reports, period, you know. So.
Well, I know for animal issues there are a couple reports, and they're in the minute books.
So it could be that a chair needs to work with Ann, and they need to work with their oldest committee members to see what they remember. So.
I would gladly work with any of the chairs to be able to find the information for you.
Good. Very good. Thank you. So with that, we're going to move on to commissioner announcements and comments. I'd like to remind everybody that the deadline to file for candidacy is today at 4:30, correct? So we'll see if we have an election or not. Are there any additional commissioner announcements or comments?
I would like to thank Mr. Schulman for his donation of advice. Take that off your income tax. We'll go back and look at the stream again, Mayor, and find out how many minutes and divide 1,000 or whatever you're getting an hour by that number, and it may work out.
Will you bail me out when the IRS puts me in jail for that?
No, we will not.
If there's no further announcements or comments, review future meeting dates. Tomorrow, Tuesday, June 7th, 9 a.m. is the Mayor and Commissioner CDP meeting. After that, June 17th at 2 p.m. is our regular meeting of the Mayor and Commissioners. Susan, what did we decide on June 21 for trees?
We're not, because I don't get
We were
back
gonna
until the 16th, so there's not time to prepare.
I had a meeting tentatively scheduled the 21st. It will not happen. Our next meeting would be June 28th, Tuesday, 9 a.m., and that is our public hearing on the CDP. With that, we'll go to Commissioner Legree.
Mayor, I'm sorry, go ahead.
You said which one wouldn't take place?
June 21.
So then there'll be no meeting that day, no special meeting.
Correct.
That's what you're saying. Yeah.
Oh, okay.
Anybody else, Commissioner?
Yeah, just for update, and I sent this out via email to all, but just a reminder for the city manager interviews, if you'd please block July 19th in the morning. We'll have, these will all be executive sessions, but July 19th, the morning, we'll be discussing with the search consultant. And then also July 27th. Again, if you'll block it, just depending on the number of applicants that we have at that period of time, but if you would please block 8 a.m. to 8 p.m. It may not be all 12 hours certainly, but just depending on where the applicants are. These will be virtual interviews, so with time changes or what have you, that may be a need for breaks in times or what have you, but just accommodate, please hold that 12-hour period. And then again, on August 15th, they will be in-person interviews. Again, that would be day from basically 9 to 5. And again, all those sessions would be executive sessions. They would be open. We would open them as a public session, then go into executive session. And just for clarification, Mayor, with regards to holidays, I've noticed, have we made the change for July 4th holiday and Labor Day to the following Tuesday? Has that been officially done, or?
Oh, July 4th is switched, 9 a.m. workshop is switched to July 5th. We still have pending a change for indigenous.
Well, it's on for September 6th too, it looks like.
Yeah.
Yeah.
And we can look at our schedules right now. Whoops, I don't have it in front of me. September 6th would be changing to what, the 7th?
No, the
No,
6th
it's on
is
the
the new
6th.
date. The 5th is the Labor Day.
The public
I'm
calendar
looking,
has that,
I'm
so.
looking at. We're looking at September
6 is the new date.
5 is going to be switched to the 6th.
Correct.
Is that all right?
And I will also schedule, with your permission, a stormwater task force meeting at 1300 on the 6th.
On the 16th, okay. Sounds good. Thank you. So there are some changes there. With that, we'll go to citizen comment. I am limiting it to 3 minutes. Jeffrey, I know you'd like to speak. We also recognize that you will likely be here July workshop. Workshops are always a Monday, except because of the holiday, it will be July 5 at 9 a.m. So if you want to give us a preview, that's fine, but I'm not expecting the whole spiel. You'll defer? No, I'll do a preview. Go ahead. But you need to come up to the lectern, Jeffrey. Again, start with your name, your address, and then just a brief preview, if you would, because we know we'll take up this topic again in July.
Yes, thank you. Jeffrey. Okay, Jeffrey Good at 1 Grove Street. Yeah, I was looking forward to talking about an issue. It's been since 2020. I wanted to get it before the whole commissioner and mayor. I know some of you know a lot about it. Like Susan was on the Streets and Transportation, head of it, and I think the mayor knows about it, and Ed knows plenty about it, but I'm not sure anyone else is that familiar. So basically what I'm asking for is that I moved into Grove Street around April 2018, and it didn't take me long to see a very serious problem. In a nutshell, it's a very busy intersection. You have not only all the Rehoboth traffic, but it's sort of a conduit from North Shore and that area, Henlopen Acres, because you can't go through the park. You have to come around Grove Street to head to either onto Columbia or towards Rehoboth Avenue. So it's a busy, busy area at certain times of the year, and there's a lot of delivery trucks, both to Royal Farms, which is across the street from where I live, and also workers who, they want to grab coffee, get something to eat quickly, coming to or from the town. Most of the people just headed to Rehoboth Avenue or headed into Rehoboth. And the problem is that, particularly when there's delivery trucks at Royal Farms, there's nowhere for the number of cars that want to go to Royal Farms to park in the Royal Farms parking lot on Columbia. So what they do is they park where they can legally. Like, we did put in 2 extra parking spots. We cost shared with the government with gravel on Columbia, on one end of the house, of my house. But in front of that, it gets very narrow. The road sort of, the shoulder becomes very narrow. So what you have is often a lot of delivery trucks, not the working trucks, they don't want to go all the way around and try to find someplace else. So they park illegally very close to Grove Street where it hits Columbia. And that's a very narrow area. And so they're partially blocking the travel lane on Columbia. And they try to get over as far as they can, but if you're a truck, you can't get over that far. They totally destroy not only the city's property, but my property where I tried to plant grass about 4 times, including, well, when we first bought the house, there was a nice grass there. That was all destroyed. And I tried 3 other times, but the trucks coming and going in that area kill the grass. And not only, sometimes I showed you guys pictures, sometimes you have the really big trucks that they'd be almost blocking Columbia completely, so they go onto the bushes and the small trees that I have also that were planted when I first bought the house, and they were damaged. So we have a consistent problem. Personally is destroying the land, the grass, and some of the small bushes. So what we did then, and the city did try to help. They put
Jeffrey, one minute.
Go ahead. All right, 1 minute. So after the city did what they could do and it didn't solve the problem, we asked for a curb. The curb went through the Streets and Transportation Committee finally in April of, we asked for the curb in 2020. The Streets and Transportation accepted it. Susan was the head of it. In April 2021, thought it was a good idea, but then the city did a cost an engineering. They hired an engineering consultant, and in May 2022, just a few weeks back, they got the result. Went again to the Streets and Transportation Committee. Ed was the chairman, is the head of that, and they unanimously accepted it also then. So. That's where we are now, that the Streets and Transportation Committee twice thought it was a good idea. I asked for a curb, mind you, but they want to put a sidewalk. And I also asked for the curb for half, not where the parking spots are, just half the distance. But because of ADA requirements, I understand they have to put a sidewalk in so a wheelchair could get on. I don't quite understand why you have to have it so long, but I don't know all the rules. So that's why I think it's important from the city's point of view, because when there are particularly trucks parked illegally, you have to go into Columbia Avenue and there are cars coming. It's dangerous for people trying to, both pedestrians, other cars making a left turn, and like it's dangerous for me. I'm on that street every day, and when there are cars parked there or trucks, I have to walk into Columbia to go down.
Thank you, Jeffrey. We appreciate you saying this. Remember, I had to take it off the agenda. Allowed this for introduction. We can't comment on any of it, unfortunately. But we invite you back to our July workshop where I anticipate putting it back on the agenda.
Okay, thanks.
Thank you, Jeffrey.
All right.
Citizen comment, Walter?
Walter Birmingham, 123 Rehoboth Avenue. The north side of town needs police enforcement. The attitude of the police department, shift commanders included, that people building houses, et cetera, have a right to do whatever they want to do. You don't have to write the time down. But we need police over there, and we need enforcement. We need no parking on the roadways. Second subject, Lynn did a wonderful job on the trash container thing. It needs support. It needs talking up. The plan, I know they'll work it out, what's going to happen if you don't have the right kind of dumpster, but the people need to know what's happening. So, thank you.
Thank you, Walter. Anybody else? I thought we'd get out of here before,
I'll be less than
before
3
1,
minutes.
but I may be wrong. Go ahead.
I have a question.
Name.
Harvey Shulman, Henlopen Avenue. I have a question on the reports and other things going on the portal. Will all those be word searchable?
They are. They are.
Okay. Because that's a great way to find the subject matter. And by the way, Ann started all of this stuff before there was a portal, and it had to do with the Baymart matter, and there was so much going on, and Ann was driven crazy by it and said, I'm going to start posting documents, and she's really done an incredible job. One request, when you post these iterations of the ordinance changes, could you please post a comparison not only of the last change versus the clean version, but post a red line version of the first version versus the last version? Because otherwise it is literally impossible to find out the change. If you have 15 changes, you have to look through every single one to see what was inserted and what was deleted. If we had a Word version of the first and the last line and the last documents, we could do that ourselves, but some people don't have that function. So a lot of times people want to say between what was introduced and what they're voting on, I just want to see those changes. And that's something that will take you all like 10 seconds, but it'll make life easier for everyone else. And I'm done in less than 3 minutes. Thank you.
Thank you, Harvey. Thank you. We'll give that consideration. Anybody else? Jeffrey, good? Different topic? Go ahead. All right. Keep it short if you don't mind.
This will be very short. Jeffrey Good again at One Grove. And actually, this is more for Jay, his group, the boardwalk. I'm on the boardwalk a lot, and I jog there or I walk there almost every day. And I don't know if you realize that there's going to be someone's going to lose an eye at the Boardwalk Plaza Hotel because they put the umbrella, this was all last year, and I spoke to the lifeguards about it. I don't think they have any jurisdiction. But when it gets hot, they put these big blue umbrellas that go onto the boardwalk, you know, from where people are sitting for their meals to shade them, but it happens to go onto the boardwalk. And it's pretty high up. It's about 6 feet tall. So if you're under 6 feet tall, it's not a problem. I've seen shorter people just running under it. I'm almost 6 feet, and I have to be, I very carefully have to get around, and sometimes you don't think. I've seen people run into those umbrellas. No one I've seen ever got hurt yet, but that's an accident waiting to happen. I don't know if it's legal or not legal, but they shouldn't have umbrellas taking up where people are jogging and walking. That's, yes.
Thank you.
Can I ask you?
Thank you.
Go ahead, Mayor.
You can, but this is not an agenda topic, so if you want to ask a simple question, that's fine, but we're not getting into a discussion up here. Thank you, Jeffrey. Anything else? With that, if there's no further commissioner comment, I want to thank you for what I thought was a very productive meeting. I'd like to adjourn this meeting at 11:44 a.m. Thank you.